calls matter of Darrell Curtis versus JPN Investments LLC, file number 24-105-944-0. It's time today set for motion hearing. Plaintiff's counsel is present. Joseph B. Gale appears in the courtroom. Defense counsel John M. Friel appears on behalf of the defendant in this matter. This matter was previously scheduled, I believe, approximately a week ago, but due to flooding in my basement, I had to reschedule. So I apologize to both counsel relative to that.
Not a problem.
When you see a 5-gallon pail flowing or rolling, not rolling, but floating on your basement floor, standing upright, it was a little concern for me. So, but I apologize for that. Where we have a number of motions. Where do we begin? Do you have any suggestions? I know I think I have an idea when each motion is filed first. Are there any issues we can resolve now that parties have agreement on? How do you wish to proceed? First, I'll ask Mr. Gale.
There's no issues that we have an agreement on. In terms of a proposal as to how to proceed, perhaps we should start with the motions for reconsideration first and move on from there.
Mr. Friel, how do you feel?
I agree with that, and his issue is older, so he's welcome to go first.
All right, let's begin that way then. And that was the one filed first.
Thanks, sir. As the court has seen in our filing, this is our motion for reconsideration of the court's order of the motion limiting for our request to exclude this lease agreement that was produced by the defendant during discovery of this case. As we've laid out in the motion, the court ruled we had initially objected on the grounds of relevancy, MRA 401, and that and under 403, that even if it wasn't relevant, the probative value is substantially outweighed by its prejudicial effect. It would confuse the issues, waste of time. The court ruled that there was a contract within a contract in that lease agreement, and therefore found that it should be admitted into the record. So the basis of the motion for reconsideration is that if the defendant is asserting a contract within a contract, therefore a contract-based defense, it was required to be stated as an affirmative defense, and the defendant was required to attach this contract to his answer to the complaint. This was brought up. The defendant actually filed a motion for summary disposition, arguing that the plaintiff was required to attach the lease to the complaint, and we responded requesting I-2 relief, stating that the defendant's defense is based on this contract and they were required to provide it, and that the court rule explicitly states that if a contract is not in your possession, you don't have to provide it. There's a specific exception for that, of course. If you don't have it in your possession, you can't provide it. And
I believe in your initial disclosures, you indicated that there was no contract, at least you possessed it.
Correct, Your Honor. Yes, we had no contract that we possessed. My client affirmed that again at an evidentiary hearing here, that he didn't retain a copy of the lease agreement. So under the court rule that requires this contract to be attached, if it even applied here, which our position is it applies to the defendant's defense, but it doesn't apply to the plaintiff's claim because it's based on common law and it's based on statutory violations. It's not a breach of contract claim. It's a common law claim and a statutory violation claim. Now, if the defendant's defense, though, is based on a contract, under the same rule, he was required to attach the contract and was required to plead it as an affirmative defense. He did neither. So I think it's a rather simple motion based on those two failures. The lease should not be admitted into evidence, and the defendant shouldn't even be allowed to proceed with that contractual-based defense.
After reading, obviously, all the pleadings in this matter, I anticipate there will be a response. Well, wait a second, in your amended complaint, you list the contract or a part of the contract. There's some sort of agreement for rent.
The only thing that was changed in the amended complaint, we had appeared here at a pretrial conference at some point on Zoom, and we had listed Joseph Nolan, who appeared here at the evidentiary hearing. We had listed him as the defendant, and we were advised by the defendant's counsel that the correct party in interest was JPN Investments. That's the only thing that was changed in the amended complaint.
Okay. I'll withdraw my question. That's my understanding.
Well,
Because that was initially at the, I believe, the first pretrial that we had in Chambers. That was
Yes.
via Zoom, and I remember, Mr. Friel stating, counsel, I don't think you have the right party, but apparently that was provided to you, and hence the amended complaint was filed.
exactly, Your
Very well. Anything else on this issue?
Honor. Not unless the court has any questions.
Not at this point. All right, thank you.
Thanks, Your Honor.
Thank you.
You're welcome.
Your Honor, I'm going to rely substantially on our filings. I trust you reviewed them. One of the things I'd just like to highlight, this argument about affirmative defenses, we've set forth what the definition of an affirmative defense is under MCR 2.111, I believe it is now. There's a distinction between an affirmative defense that has to be preserved, in which 2.31 or 113C, I believe, is the court rule that requires the attachment would apply. I draw the court's attention to responsive allegations, as opposed to affirmative defenses per se, which are basically like well, the best example is the release that the court excluded already. We're not challenging that in terms of a reconsideration, but the court went through and blacked out release language and also hold harmless language. Those would be affirmative defenses. If the statute of limitations is brought on the action, that would be an affirmative defense. But to allege, and I'm thinking paragraphs 42 and 43, I know I looked at those this morning of our responsive pleadings, assert you had actual knowledge of the danger. Now, the lease acknowledges that also, because as the testimony was at our evidentiary hearing, Mr. Nolan indicated that he was unwilling, the property wasn't ready to be leased yet, substantially because of these dangerous stairs in the front. And the idea, the deal that the party struck was that he wouldn't use the front steps. Well, he disputes this, but he was supposed to fix them. But it was clearly understood that he wasn't to use the front steps, he was to go out the kitchen door, out by the garage, until the steps were ready to be used. And then, of course, he fell before that happened. He says, we dispute that. It's not an affirmative defense, that doesn't apply. I think it's interesting that one of the items of, I guess I'll say alleged authority that was offered to the court today by plaintiff is a circuit court opinion from Oakland County. It says right in it, it is true. This is talking about with respect now to the statutory contract action. To say that that's not a contract action is to like to say that a PIP action is not a contract action, because there's a statute involved. The statute says what the no-fault policy has to provide. So it's a combination of the insurance contract and the statute. The same is true here. And as plaintiff's own authority says, it's true that the duty of care arises only when there's a contractual relationship. And in this case, that he cites, it's a lease. So the court correctly ruled that the lease is relevant. It's relevant for a number of reasons. It appears to be necessary to the cause of action, the statutory contract that count one, I believe it is here in this case. It's also,
And I always get that confused. Is count one the common law, or is that the?
count two is the common law. Mr. Gilpin, correct me if I'm wrong, I believe count one is the statutory contract. It is based on the lease. And as I believe the circuit court, it's not obviously compelling authority, but as the court, it's like the only thing they don't the duty of care doesn't even arise in the absence of a contract. So we would argue that they were required to attach the lease. We have the lease. They say, well, that's not the lease. We like everything except the first page. The court said some of this stuff I'm not going to allow. The idea that they're actively releasing the landlord and the idea that they're holding them harmless, those have been blocked out. So what's being argued now, if I understand it correctly, is that the court either, going back to the original motion, which I think we kind of have to do, either is not relevant, which we strongly disagree with that for all the reasons that we've given. This is, I think, the third time we've argued that altogether. You count the original hearing, then the evidentiary hearing, and then now. But also, I believe that if they even, it's not, we're not making an affirmative defense, other than if we had said, you can't sue us because you released us, you also can't sue us separately because you held us harmless, which is not an assertion that's found in our responsive pleading. That would be an affirmative defense. Then there might be an argument that it has to be attached, but it should also, it's responsive to the original action, which, as the case correctly says here, there's no duty of care unless it arises out of that contract. So to say that the lease in the middle of all of this isn't relevant, we strongly disagree. And beyond that, I'll just rely on what we filed with the court.
Very well, thank you.
Thank you.
Mr. Gale, rebuttal on this issue, please, sir.
Yes, very briefly, Your Honor.
Just to briefly touch on the issue of relevance again, the defendant is coming into court here and telling you all of these arguments that he's making about this contract, that contract, as the court put it, that that's their defense to the case and it's relevant to it. But if it's not pled as a defense, and if it's not attached to the answer to the complaint, the defendant can't assert it as a defense. So while the defendant wants to, it's relevant to these arguments that he's making here today, but it wasn't properly preserved as a defense, and therefore it isn't relevant to any defense that can be raised at trial. I didn't even hear the defendant explain how he gets out of not attaching this contract to his answer to the complaint. Again, it wasn't in our possession, so that even if it did apply to our claims, there's a direct exception. Court rule is MCR 2.113C1. It requires the defendant to attach it if the defense is based on a contract. There's no requirement for a party to attach anything if it's not in their possession, which my client testified here at the evidentiary hearing it wasn't. So for all of those reasons, I would ask that the police be excluded.
All right, the issue is a motion for reconsideration relative to the court's position pertaining to a ruling on the lease, this alleged lease. And by the way, I say alleged lease for a couple of reasons, because there was an evidentiary hearing here previously. The defendant and the defendant's assistant, if I recall correctly, testified as to a 2-page lease. The plaintiff, on the other hand, recalls signing a 1-page document. That's what the court recalls. Doesn't recall anything regarding the first page, which contains these provisions and what the court deemed to be essentially a contract within a contract. And so there's even disagreement as to whether, or basically, it appears there's an agreement there's some form of contract, at least 1 page. As to 2 pages, defendant says 2, plaintiff says 1, plaintiff claims he never received a copy of the contract. So at the time this action was filed, and the defendant's position has been, well, they should have attached it to their pleadings, but according to my reading of the file, at the time of responding to all of this, plaintiff did not have one, period. So there's no, I'm not questioning counsel. Counsel didn't have it. Counsel didn't have it at the time. Now, apparently the defendant did. And so I have to start with that understanding, because we can't even agree whether it's a 2-page lease or a 1-page lease. We don't know. That may be up to the, I don't know. But at least what I have now is at least testimony from the plaintiff that he signed a document, and I believe it was at the office of the defendant just south of Fillion, but he never received a copy. Now, when you look at a motion for reconsideration, the moving party must demonstrate a palpable error by which the court and the parties have been misled and show that a different disposition of the motion must result in the correction of the error. That's citing MCR 2.119F3. And now, generally speaking, when a motion for rehearing or reconsideration merely presents the same issues, by whether expressed or by implication, the motion will not be granted. What we have here, though, is the plaintiff's position under MCR 2.113C1 that a defendant never pled a contractual defense as an affirmative defense. According to the court rules, all affirmative defenses must be pled in the next responsive pleading. Clearly, that was not done. And so the question is, what is an affirmative defense? And again, affirmative defense pled under MCR 2.11F3 An affirmative defense is a defense that does not controvert the plaintiff establishing a prima facie case, but otherwise denies relief to the plaintiff. And so, for instance, statute of limitations, other C1, C7, C, whatever it may be, those have to be pled, and that would be a motion to obviously to move this thing along. Now, the plaintiff's position is that because it's deemed basically a contract within a contract, it should be pled. Plaintiff, if I recall correctly, after reading the transcripts and hearing his testimony, plaintiff doesn't even acknowledge that they had some sort of an agreement relative to repairing the steps. Defendant does, plaintiff doesn't. So the question is there even a contract? But regardless of that, here, if anything, the purported lease, if admissible, is evidence that the plaintiff is not entitled to prevail on his action because that is evidence to the issue of breach, i.e. forewarning, and not providing knowledge to the plaintiff of the condition. So I can't even call it a contract because the plaintiff doesn't even say that they reached some sort of an agreement. Defendant does. The document, apparently page 1, indicates that there was, but plaintiff doesn't acknowledge page 1. Matter of fact, the plaintiff's position is that these are essentially two different documents, because when you look at the page numbering on page 1 of 2 and 2 of 2, they're different. Again, I wasn't there, so I don't know. But to sum it up, I find that whether you call it a contract within a contract or anything else other than that, it's not what I deem to be as a definition of an affirmative defense. As a result, it need not be stapled to the defendant's responsive pleadings. Otherwise, that would be required. The motion for reconsideration is respectfully denied. Let's go to the next issue regarding motion for reconsideration. And this is regarding the common law.
So we're gonna move to defendant's motion for reconsideration?
I believe that was the only issue, correct? Regarding the motion
Yes.
for reconsideration, Mr. Gale?
That's correct.
Yes, Your Honor.
Okay, I just wanted to be sure.
Okay, defendant had filed a motion for summary disposition seeking to dismiss the entire action, count 1 and count 2. The court respectfully denied that motion. While we may not agree on either count 1 or count 2, the motion for reconsideration is limited only to count 2, which is the common law claim. The palpable error that, again, we respectfully assert was made is that it appears that the court took the fact dispute from count 1, which is a statutory contract claim, and concluded that there was a fact dispute as to also the common law. Now, the duty structure in the premises liability claim arises exclusively from the common law. The common law says that the duty to warn ends when the person has actual notice of when the plaintiff has actual notice of the alleged defect. In this case, there's no dispute. Not only, well, there was a dispute, but I don't think it was a material dispute. The argument I went along the lines by plaintiff of plaintiff told defendant that the steps were dangerous. Defendant didn't warn plaintiff. Of course, the disputed fact, and this is one of the many reasons we say the lease is relevant, is that it acknowledges right in there that the stairs aren't to be used until they're fixed because they're too dangerous to use. So notwithstanding complaint allegations that say I had no other way to get out, which we know isn't true, or that I think there's even something about ice and snow was something that we reserved, and that's probably just copying and paste from a regular slip and fall case. We think the court respectfully erred by finding a fact dispute when there is none as to the non-existence of the duty. There's no dispute that, and the plaintiff said so himself at his deposition that he knew about the steps before he claims he used them and fell on them. That ends in the duty. There is no duty. There is no count 2, and count 1 would remain per the court's ruling. Other than that, I'd be happy to answer any questions, but I'm going to rely on what we file.
Thank you. Mr. Kim.
We filed a fairly thorough response. I'll try to just touch on the main points. The first one being that the defendant is essentially asserting the old open and obvious doctrine that was overturned by Candle El-Sayed. And what was really telling in the defendant's motion for reconsideration here, and if the court recalls, this was filed at like 4 p.m. the day before the prior trial was scheduled.
January 5th.
And the defendant attached an unpublished case, this case, Sarah Lamb versus Myers. And obviously, unpublished cases need to be attached to a motion when it's submitted to a court. The defendant did not attach the full opinion. There was a dissenting opinion to that, a very well-reasoned, long dissent that the defendant didn't attach. I've attached the full opinion to my response, and that dissent is highly relevant to the issues that the defendant raises here. So in that case that the defendant is relying on, there was a bright yellow warning sign inside of Myers indicating that there was a wet floor. They said that warning was enough. That's all that case held. That warning was enough. The dissent went through a long explanation how after Candle El-Sayed, even a bright yellow warning sign wouldn't be enough. And this was just ruled on. This very well may go up to the Supreme Court. But there is no yellow warning sign here. So all of the defendant's arguments, if the dissent was able to put together that well-reasoned of an opinion in the Sarah Lamb case, even when there was a bright yellow warning sign, it fully explains why this motion for reconsideration shouldn't be granted. Because the open and obvious doctrine was overturned. It goes to breach. That's a question of fact for the jury. To the extent, the defendant is citing some out of context statement made by the court, citing the statutory violation, I've laid out why it's a distinction without a difference. Landowners have a special relationship with invitees that generates an affirmative duty to protect. Okay, that's going back to the 1988 case law cited again in Candle El-Sayed. And so the affirmative duty to protect, the defendant is claiming that that affirmative duty to protect was met by contracting, or whatever we want to call it, with my client, the tenant, to fix the steps. So that he denies that he ever agreed to that. All of the other defendants' arguments about him having knowledge of it, the defendant hasn't cited any case whatsoever with a similar holding where this is a unique factual pattern. And I remember we got into it last time when we were at the initial hearing on this motion for summary disposition. I mean, it's a unique factual pattern. The defendant's suggestion, he cited no case with remotely similar facts where a tenant would complain to a landlord about an issue with his property. The landlord then ignores his requests for repairs. The tenant then gets injured, and the landlord says, well, you can't sue me because you complained about it. You were aware of it. There's no case that says that. There's no appellate case that will ever say that because it's utterly ridiculous. The defendant is just citing some out of context statement from this Hoffner case, which again predated Candle El-Sayed. And it's not the holding of a case. It's just a sentence in the case that if someone had awareness of something, that would fulfill the defendant's duty. But I'm kind of getting off into the weeds here, so I'll try to stay focused on the main points. The main point is that Candle El-Sayed overturned the open and obvious doctrine. Whether the defendant was aware of, or whether the tenant or plaintiff was aware of it or not, goes to breach. It's an issue of fact for the jury. And the defendant hasn't pointed out anything in his motion to change the outcome of the earlier ruling. So I'll be happy to answer any questions the court has.
Thank you. Response,
Sir.
or rebuttal, I should say. And I'd like your opinion regarding Candle El-Sayed versus FNEOL.
That's exactly what I was going to do. That was going to be the main point of my rebuttal. And excuse me, because I put on some old glasses this morning because I thought they matched my shoes. And I find that I need to go see the doctor. So I was hoping I wouldn't have to read anything, but I do. Respectfully, Mr. Gill has misstated our position. Candle El-Sayed was decided in 2023 as a post. It's seminal post-open and obvious case. As we've indicated, as part of the breach inquiry. I'm talking about breach of duty. There is no duty. When you're talking of the duty is when the plaintiff is unaware of the danger. There's a duty to warn, or thing B, or thing C. I'm calling them thing B and thing C, they don't apply here. The dude, he was warned, he had actual knowledge. A plaintiff is considered to be warned when they have actual knowledge. And that's the point of the Meyer case, which I believe came out like the week after we were here for the evidentiary hearing. And so it's a very, very recent case. Candil El Sayed also cites the Hoffner decision, which says, I'm just going to try to summarize this here. Michigan law provides liability for a breach of this duty. Premises, the possessor knows or should know the dangerous condition, which we admit it is known here. So the whole point is, didn't even want to rent it. That's a little bit frustrating, I'm sure, to my client. Dangerous condition of the premises of which the invitee is unaware. And, here's where it's and fails to warn the invitee of the defect. So for Mr. Curtis to claim that he's not aware of the defect, the fact that it is open and obvious can be considered as part of that. Before Candil El Sayed, the law with the open and obvious doctrine went to duty. The possessor doesn't have a duty to warn of something that's open and obvious. And a lot of people on the defense side say, well, that's not fair. The Supreme Court changed that. No, it is fair. It's kind of now a comparative fault type of a thing. If the steps are as bad as Mr. Curtis says, the plaintiff, then what the heck is he doing walking on? It's like, let's cut the porcupine. If your mother didn't tell you not to cut a porcupine or pull on a skunk's tail, you should know. You should know. You should be able to tell by looking at the porcupine at least. Maybe some people think a skunk is a cat, and want to cut it. We had a dog like that when I was growing up. She came home with porcupine quills in her nose all the time, and she didn't last very long. She got hit by a car eventually. The possessor of the land is not responsible for overt stupidity at one end of the spectrum, but then as you get to the center and it's more and more gray area. That's what Khalil El Sayed is talking about in the modern now post open and obvious era, and the law we're citing is absolutely on point. The Meyer case is cited by plaintiff also. Basically says, and he just heard plaintiff counsel say so. The warning sign is good enough. What's the point of the warning sign? To put you on notice. If you already actually know, and you go ahead and you walk on the slippery floor anyways, where it says keep out, like we assert in this spot, in this case, and I understand that that's disputed. Nonetheless, by his own testimony, Mr. Curtis, the plaintiff, is aware of the condition of the steps. He says he used them anyways. He says he fell on them, but there is no breach of duty if, as Khalil El Sayed, quoting Hoffner, says, the invitee is unaware when the possessor is aware of a defect that the invitee is unaware and fails to warn. In this particular case, there was actual notice of the defect, not even an argument constructive, which would probably suffice.
Based on what?
Based on his testimony saying he knew all about it before he fell.
Okay.
He says, and I think this is a meaningless, in other words, immaterial dispute. The argument from plaintiff is, well, he told Mr. Nolan. Mr. Nolan didn't tell him. The point is that he knew, and that's the point of the warning. When you have actual notice, you don't need a warning. But to the extent that he admits that the two of them discussed it, he says on multiple occasions before, he says he slipped and fell. He has actual notice of the defect. And for the court to say there's a fact dispute on the statutory contract claim, count one, and therefore somehow that applies to the common law claim, that's what we're asserting. That's what we've identified as a culpable error. And so we're only asking you to reconsider your decision as it applies to count two. Count one is what it is.
So explain to the court again what you feel the duty is of the possessor of land relative to a common law action such as this.
they have a duty to warn of a defect. There's three different things they could do. They could repair it, they can take other measures to protect, or they can warn. Or when the invitee, in this case, that's what Mr. Curtis alleges he is as a tenant, is unaware of the dangerous condition. In this particular case, that duty doesn't apply because he is aware of it. And he said under oath that he knew about it before he filed. I asked him point blank, it's in there.
I recall the testimony because it was regarding the monthly rent payments. There was discussion about that.
He says, I warned him every month. So you knew before you filed? I asked him, he says, yes. That's actual notice. He's been warned. Whether he warned himself, and Khalil Al-Sayed says that whether it's open and obvious, whether you should know, can be taken into account when determining this new structure that I'm describing. So the duty, there is no duty in the common law. Now, the duty is different because that derives from the lease, as the Oakland County Circuit Court correctly notes. And I wasn't aware because I don't read Oakland County Circuit Court opinions. I get enough of them that involve me directly that I developed a bad taste. But thanks to opposing counsel, we're aware that that is the law. And so those are distinguishable, and that's what we're respectfully asserting to be the culpable error is inflating the separate standards of care and whence they come for these two different counts. And presumably there's a reason the plaintiff wanted to plead two different things. There are two different ways to get you. Unfortunately, when you're aware of the danger and then proceed to use the stairs anyways, there is no breach of duty because the duty doesn't extend to that situation. And that's what we're asserting in our motion.
Thank you.
Robert, can I briefly respond as to the plaintiff's knowledge?
Sure, go ahead.
Thanks, Rick. I just want to briefly make the point that plaintiff complained that the stairs were falling apart to the landlord and they needed to be fixed. That's different than having specific knowledge that they would break underneath him and that he chose to walk on it and suffer an injury. That's a comparative fault issue, and it's an issue for the jury. I just wanted to briefly make that point.
Response.
It doesn't change the fact that he had actual notice, Your Honor, and it's again, an immaterial distinction to say he can see the stairs are falling apart. He didn't know that he couldn't walk on them because they might be dangerous. He knows the only danger they've identified is the same danger he acknowledges being fully aware of. It's actual notice. There's no duty to warn when you already have been warned, just like there's no duty to go beyond the Myers sign. It's there to say, I didn't know what that stick figure slipping on the sign meant. That's not recognized by the court as being a legitimate argument. That's not a material fact.
Thank you. All right, the court applies the same standard relative to any palpable error. The party must demonstrate the moving party that court was misled or show that a different disposition of the motion must result from correction of the error. Again, citing MCR 2.119F3. And as stated before, motion for rehearing or reconsideration that merely presents the same issues will be respectfully denied because, again, there was nothing new or anything that the court did that was either incorrect or wrong. Here, we are dealing with a summary disposition motion relative to count 2, which is the common law action. And at the hearing, original hearing where the court made its final ruling on this case, the court found that summary disposition was not appropriate relative to count 1 and count 2. Again, this is merely count 2 that we are talking about. And when I reread the opinion, or I should say reread the findings, not only the findings, but my ruling, I was kind of mixing really the statutory duties as well as the common law duties. And it's clear in the record what I did. And I acknowledge that. And I'm wrong in that regard. The issue here, though, is under common law, whether or not, again, the issue pertaining to the duty of, it really comes down to breach here regarding warnings, regarding the condition of the property. And according to the pleadings and the testimony, according to the defendant first, I'm not leasing it to you because it's not ready. The steps are in bad repair or bad condition. And the defendant went further on to state that I wouldn't say felt pressure, but he was asked essentially to reconsider that decision because the plaintiff wanted a place, whether it be for his tools or whether it be for storage of something else or living. I believe his daughter may have lived down the street, but regardless, the plaintiff, according to the defendant, needed a place to put something or to put himself. Plaintiff, on the other hand, denies that first there was ever any discussion regarding steps, that he was never warned, that was never brought to his attention. And so when you look at that initially, there's clearly a question of fact, because at that point, one says one thing and one says the other. But now when you apply the Kandil El Said case, and that was I believe was the Meyer case, involving the slip and fall and the yellow placard thing that goes on the floor. The duty here is obviously not only to protect the invitee, but also to protect the invitee regarding conditions that were unaware to the invitee. The plaintiff's position is, well, the steps certainly looked like they were in disrepair and falling apart, but not to the extent that they were going to break apart and plaintiff suffers injury as a result of a fall, which would tend to lead or lend itself to, again, a question of fact of comparative fault. Let the jury decide. On the flip side, the defendant's position is, well, wait a second. Even presuming that there was no warning beforehand, though defendant claims he did. Defendant claims that he warned in the contract, at the meeting site where they were discussing the property, the rental. Defendant claims, again, he was warned, don't use the steps, use the back door. I recall all the testimony. But even if that were not true, there's testimony in the record clearly indicating that the plaintiff was aware of the condition, because it was either by phone call or meeting regarding payment of rent or discussion of rent that plaintiff kept complaining about the condition of the steps. You need to fix the steps. You need to fix the steps. You need to do something with these steps. Now, again, there's argument back and forth regarding who warned first, but you have to looking at El Said, the other cases. At the end of the day, you have to look at very simply, was the invitee, quote unquote, warned? The invitee plaintiff had actual knowledge of it. Not necessarily by the defendant's allegations that he gave notice. That's certainly a question of fact for the jury. But when it comes to having actual knowledge of the defect, plaintiff repeatedly complained of it. And there's the actual knowledge. And this court finds, when you look at that and you compare that to the yellow sign, placard, etc., relative to this being not only, but also I think open and obvious. I understand open and obvious is in flux here, but plaintiff had full knowledge of what was going on with those steps. The court committed culpable error, and the court reverses its decision relative to summary disposition pertaining to count 2 only, and I'm granting the relief as requested, dismissing count 2.
Thank you, Your Honor.
Orders need to be prepared in each of those rulings so far. Let's move on. What's next?
What would you like to do next?
We'll leave that up to the court. I have no preference.
Okay. Let's see, let's go down the list. How are we doing on the objection to proposed orders? That was December 23rd. That was fine.
That was my objection, I believe. I can
Yes.
address that if you'd like me to.
Sure.
Actually, Your Honor, I have very little to add to the objection. The motion, well, for me, I'm just trying to think really quickly here. If your ruling just made changes anything, I think the problem we had with the order that was submitted by plaintiff is that they had also requested I-2 relief, which was denied, not just the relief that was issued as modified just now. I think that was the problem with the, that was the problem with the dispositive order. And then there was an order submitted on a motion in limine, a plaintiff motion in limine.
Disallow non-impeachment testimony of Dr. Algren.
There was our understanding, and I cited the transcript section that caused it, is that plaintiff was allowed, we had not retained any expert witnesses, paid experts, but we were going to rely and are relying on the treaters, of whom, plaintiff is aware. My understanding was that we were allowed to call treaters and that we were allowed to also impeach, as long as the rules are followed, rules of evidence. The way the order is worded, we can't call anybody with expertise, even treaters. And we wanted to make sure that's clarified. I think that's still an issue. I mean, that's come up in objections when we started to take trial testimony. But my understanding, and it is consistent with my history of experience on all my cases, is that when you say treaters can be called, that's different. If they're kind of a hybrid of a fact witness. There's facts that they may know, and there's also expertise that they possess. You're in the emergency room, or you're on the surgical table for a reason, and hopefully they have expertise and they're not going to just start slashing at you. So that was the other basis for our objection on the orders, is that it could be argued that the order as submitted would not allow anybody with expertise to be called as a witness if they were asked for an opinion that would require expertise to do so.
My understanding was you were not going to call your own individual experts. You cited no expert witnesses at all.
We did not, for example, I'll just think of the last trial, list an orthopedic surgeon of our own to do an IME or to review medical records, and then to give opinions that, no, this is chronic, it's not acute. The surgeon fixed something that was going to have to be fixed anyways. That is an argument in this case. However, the main thrust of what we wanted to say is that when he went to the emergency room, his treating physician at the emergency room testified. Now we know in December we had to speculate as to what we hoped she'd say, but now she's testified that he not only denied being in an accident or having any kind of an acute injury, but that his pain had built up over days as he installed and lifted heavy tile, and that it was a chronic condition. That was part of her, I'm kind of bleeding into another issue. My problem is we're talking right now about entry of an order. The order that was supplied by plaintiff suggested that nobody with expertise could be called. And I had understood that the court was very explicit that treaters and impeachment witnesses could be called, but not paid experts. We bring in who aren't treaters, who are looking at the medical records or looking at the plaintiff and giving an opinion. And we're not saying that we're going to offer anyone like that. And often we do, but in this case, no.
Your Honor, first of all, with regards to the order for the motion for summary disposition, I would defend attach an email that he sent to me where he expressly said, in the third paragraph, defendant will not be objecting to the wording of the order denying defendant's MSD per the record. He then objected to it afterwards. I don't really have any issue with having it also say that the I-2 motion was denied.
How do you feel about that, counsel?
About
email? I know that's just
I have-
communication between
yeah.
the two of you.
I'm not sure that's what I said in the email, and I don't want to misstate it. I mean, it's right there. I said, I'm in an accident reconstruction about most of tomorrow, so I wanted to reach out to you preliminarily on these orders this evening. I don't offhand have a problem with the wording of the proposed order denying defendants' second and third motions in limine, given the record. Defendant will not be objecting to the wording of the proposed order denying defendant's motions for summary disposition for the record. Yeah, I don't think at that time it had occurred to me yet. That was right away. And when I went back and reviewed it, I realized that the I2, that's a minor consideration, but yeah, that would be, that's me after when I probably sat down to, my main concern was Dr. McKay. And the fact that the order appeared to be eliminating any physicians as opposed to treating physicians, which I understood was an exception. And then when I went to do the objection on that, if that was my main point, I think I realized that the I2 had been left out and I added that in. That's my best explanation.
So how do we remedy this?
I guess I was just pointing that out. I don't know.
Why, I just want it clear, that's why. And I mean, no disrespect to anyone, I just want to make it clear for everyone, including the court, frankly.
The objection is what should speak for our position. If I hadn't thought of the I2 thing at the time that I sent this email, which I didn't get a response to, then I thought of it after I sent the email is all I can say. That appears to be the case.
I guess I don't really care whether it also says that the I2 motion is denied as well. I'll leave that in the court's discretion. I'll move on to the next.
Let's do that.
Okay. All right, and I'm not sure if any of the orders have been entered from that day of the 7-day orders that I submitted.
That we have a pile of them, I don't think so.
All right. All right, well, we can get that resolved, I guess, after this. In regards to the other order about plaintiff's motion and limiting or precluding the expert medical opinions, from what I recall, the court granted the motion. There was some other issues raised by defendant's counsel about whether he can cross-examine the doctor and whether he can impeach, testimony that's being given. And the court said, of course, you can cross-examine them. I don't think the court said it wouldn't even have been an issue in the motion. So I don't know how defendant's counsel is thinking that the court's order gave him some sort of leave to call this Dr. McKay and somehow expanded his witness list that he's now able to affirmatively call every one of plaintiff's treating physicians that he never identified as a witness. The point of the motion was to exclude the defendant from calling any expert witness or offering any expert medical testimony because we weren't given notice of it. We sent discovery, it wasn't provided. I mean, we're not here on a motion for reconsideration of this. It's just about what the court ordered. I recall the court saying the order was granted, but that the defendant obviously can cross-examine the witnesses or can present impeachment testimony. Obviously, there was, I'm kind of getting into other issues that I guess are an issue here today, but I guess it's relevant because defendant's counsel just brought it up, and that was his issue, was so that he could call Dr. McKay.
Who was a treater?
Who was a treater, yes. And when we were here on these motions in limine, the defendant attempted to introduce this improper ER document. And I didn't have to raise the issue to the court. I didn't have to put the defendant on notice of the issue. I just responded because the defendant had filed some vague motion about excluding hearsay at the time of trial that the court denied. And within that motion, he cited this inadmissible ER record. So I responded with the Supreme Court case showing how that's inadmissible.
And call that.
Yes, and the defendant responded to that. We were a couple weeks out of trial. It's not, I wasn't, this wasn't an opportunity for the defendant to fix his errors. And, I was just putting the court on notice that would be inadmissible at trial. Then the defendant amends his witness list and notices her deposition. And we're gonna have to go through that for a long time about the objections to her deposition. But anyways, that all kind of arose out of this. And I guess the defendant is saying that's his issue with this order, was that so he thought the court was ordering that he could call Dr. McKay, even though he didn't list her as a witness, as an affirmative. I don't know if that's an expert or what that is. But if he was going to do that, again, we're not here on a motion for reconsideration, but if he was going to do that, we were entitled to be provided that information and discovery and know who he's going to call and what his theory of the case is. He didn't do that, and from what I recall, the court granted the motion and the order represented as proper.
And I believe the court granted the motion regarding expert witnesses because obviously you require you have to have notice of it and provide the information to the opposing counsel. I compare it to a criminal proceeding where if anyone's going to call any expert witnesses, you have to make sure the CVs, all that stuff is in there so that there's no surprise. But I also recall that during the course of that argument that was going on, and counsel or the record can correct me if I'm wrong, my understanding is that the defendant's counsel was not going to call any expert witness, that he was going to call treaters, apparently, of the defendant. And based upon questioning, whether it be impeachment or whether it be anything else, as long as the rules are followed, he could do so. That was my understanding. Because he's not calling any expert witness per se, because he's not given notice of that.
I guess that, I think you're indicating so that therefore, even if the defendant didn't list witnesses or identify them in discovery, if they treated plaintiff, he can call them a trial, and we have no right to know who that's going to be or what they're going to say.
Well, I do recall in the responsive pleadings of the defendant that, well, I'm going to let counsel make the argument regarding that. There was a list that was provided, but not a specific name. Is that correct?
Your Honor, we listed by category, a couple of different categories that Dr. McKay falls into. And there's one other thing too that I'll add quickly when I tell you, after I tell you this. We listed all treaters, we listed all associates of McLaren Health, and we listed emergency room treaters. He knows he went to the emergency room.
And there were some physical therapists.
We listed specifically some emergency room physicians by name who he had seen on occasion. It wasn't until after the hearing on the 16th, and we didn't even receive all of the Dr. McKay records until late in the day on the 18th, and I supplied them on the 19th. But Exhibit 5A, which is the real bone of contention, that's the physician's note from the day that Mr. Curtis says he went to the hospital, where he denies injury and says, my back has been hurting for days. It was provided to us by Mr. Gale, provided to the insurance company by Mr. Gale before the lawsuit was even filed. And I didn't know that on December 16th, or I would have pointed that out on top of it. So it's a little bit disingenuous to say, we don't know. He only went one day. There's only one physician that saw him. And we said emergency room physicians, McLaren physicians, and we also listed some specific physicians who we may end up calling because it has to do with other visits to the emergency room that would explain why he has his back the way it is. It had nothing to do with my client. So I laid out everything I knew when we were on the 16th, and it was quite an extensive conversation. And one of my concerns that day, not realizing that just in a couple of days I was going to finally get these records we've been seeking for months at that point, was that some of there's only 12 pages that have anything to do with Dr. McKay at all. And that includes nurses who were working under her that day. All of that information was provided to counsel prior to any trial testimony. And the date that was picked by plaintiff. They unilaterally noticed Dr. Aldrin on the 30th. I asked Dr. McKay if she could also appear earlier, one in the afternoon, one in the morning, and she said yes. And that was something I anticipated as a possibility and disclosed to everyone when we were here on the 16th. So there was plenty of time to go through records that were in their possession. On the 19th, they were sent again. But looking back into 2024, Mr. Gale's office sent them to the insurance company. The Exhibit 5A, what we've now marked as Exhibit 5A, was supplied by them. His doctor, and by court rule, I think it's 2.314A3. The records, a person's own records, are deemed to be under their control, whether they have actual possession or not. So that's a lot different than if we were to come in with Dr. Calcanus, we like to use, from Henry Ford, and say, hey, we're going to call him a trial. There's no, sorry, I didn't mention that. The other thing too is that Dr. Aldrin was listed like 150 days after the deadline, and he's not anybody we knew about. Mr. Curtis fell down or hurt his back at work in January of 2025. In February of 2025, he saw Dr. Aldrin for the first time. Their witness list was due in March, and he doesn't appear on it. He's not listed until July. And yet somehow saying, we're going to call potentially your emergency room physician They know who that is. And if I got the wrong doctor's name, because I did list some emergency room physicians, if I got the wrong name, I'm still saying I'm going to call treaters. And it turns out to be Dr. McKay. And that was well in advance, and the records were there, and there's only 12 pages. So I don't see what the harm or foul is. And we listed, I thought we had listed Dr. McKay, but when plaintiff started to make the argument, we got closer to trial, we did a list where we paired out the people that we knew we weren't going to call, and we specifically named Dr. McKay in the spot where we had previously said emergency room physician.
We're going on, we're getting way off track here, but there are numerous other witnesses listed on this condensed witness list, including witnesses that were called at the evidentiary hearing that weren't listed on the initial witness list. So I don't know why defendant's counsel, I'm sorry for cutting him off and jumping in here, but I don't know why he's representing that he just condensed it down and felt that he listed the witness before. He clearly only listed the witness after I cited the Supreme Court case that the ER record would be inadmissible, and then he changed his whole theory of the case and noticed your deposition and added her to the witness list.
Well, there's a statement made on the record here that your office received this information and sent it to the insurance company. I can't ask you to divulge any privileged information, but apparently that's what's being stated here. Was there some sort of notice, or?
I don't know whether that's true or not, but we certainly have the emergency room records. I don't deny that. But that's a different issue than procedurally being required to list a witness that you're going to call at trial. I mean, the court's scheduling order is clear. Any witness not listed, unless good cause is shown, which we have for Dr. Elgren, because we didn't know about him until my client's deposition when we all learned about him at the same time, and then we amended our witness list. Unless there's good cause shown, they cannot call the witness. So they can't show good cause, other than I guess he's saying he didn't think it would be an issue, but he still is required to list the witness just as we'd be required to. And he's made that same argument.
But it appears defense didn't know the witness's name until later. That's what I'm gathering. Because he listed treaters, McLaren emergency room, etc.
Well, then how, if he has this record apparently from the insurance company, wouldn't he have known the name through that?
No, the insurance company told me after the 16th that he had given it to us when I told them that he was claiming that he didn't know anything about Dr. McKay. I believe that it was sufficient to list by category, to say emergency room physicians, McLaren physicians, treating physicians. That is a different dynamic. They have their records, we don't. If we hire an expert, then they don't know what that person's going to say. There's rules about IMEs, for example, that would be analogous to that. But we named her specifically as part of a pared down list. It wasn't, that was not a device that's centered around Dr. McKay. That's something we always do as we get closer to trial. And that way it's also intended a lot of times as a courtesy to an opponent to not have to prepare for 50 other witnesses that aren't going to be called.
And again, there were additional witnesses, including Gina Voles, who was here at the evidentiary hearing. She was never listed as a witness, never discussed in a deposition, never put on any notice, and he calls it a condensed witness list and adds her name to it, including others.
We listed, it's an LLC that's a defendant. We listed agents, representatives of the LLC, including its owner, who doesn't seem to have a problem knowing that that's Mr. Nolan, and its designated property manager, whose name I did not have at the time that the witness lists were due, but nonetheless, that's the designated property manager. It's listed by category. And it turns out it's Gina. And there was no problem with that when plaintiff counsel wanted to cross-examine her on December 16th. Now there's a problem.
I had no choice, Your Honor. He's presenting a witness. I had to cross-examine her. The defendant is required. And again, the defendant keeps making these technical arguments. The defendant, so I'm of course going to assert the same argument. He has initial disclosures. If there's someone named Gina Voles who was a witness to this alleged agreement that my client was going to fix the stairs, he has to disclose that there. I mean, there's numerous steps along the way where she was never disclosed. And I'm just adding, we're kind of getting onto a different argument here, I guess. We're still just talking about this order about our motion to eliminate about experts, but I'm just adding, it wasn't a condensed witness list is my only point. It added new witnesses.
Your Honor, if I may, they did know about Dr. Albrin. He had seen him in February. And he's saying, well, I didn't know until I listened to you ask my client about him. That was after the deadline. I don't believe that technical deadlines, when the court at that time thought that trial was going to proceed in June and made a deadline of March, and then trial ended up being in January. I am not complaining because I had time to find out about Dr. Algren. The important thing is the substance. Did I know that eventually, whether it was before or after the deadline? Yes. Did I get a chance to get his records? Yes, it wasn't easy. And we got different records than we were given. But nothing that I think matters. That's what happens in life. The same thing's true to say, we're going to call emergency room physicians. He says he went to the emergency room on February 27th, 2023, to pretend that you're surprised that only emergency room physician he saw on that day would be included in the category of emergency room physicians is disingenuous. And I don't think that a deadline in March that applies to a trial in June necessarily has to be held against either one of us. But if it's going to be held against defendant as a technicality, then it needs to be held against plaintiff, because it's not an excuse to say at the end of March that you didn't know that more than a month ago you went and planned surgery with a Dr. Algren, who we have no way to know about, as opposed to them knowing who their emergency room physicians are. And her name, it turns out now, appearing in a record that they sent to the insurance company prior to filing suit. It's about notice. It's about not surprising and ambushing. I don't think anybody's been surprised or ambushed here, to be honest. But we're going to have the same deadline rule for both people. I would urge the court to consider elevating substance over form and saying, look, you've both had enough time. You're not calling Mr. Friel anybody other than Dr. McKay. And if you want us to take Dr. McKay's testimony again, we can. If he's saying this isn't fair, I didn't have her records. I didn't have the record because I sent it to the insurance company 2 years ago and I didn't keep a copy, like I didn't keep my lease. I don't think that's a plausible way to handle dispute resolution in trial or otherwise. If we have to, Dr. McKay can testify again. There's only 12 pages, and I think we only use 6 or 7 of them, as opposed to Dr. Algren, where there was unmarked, non-paginated lot of documents, and I didn't even complain about that. There's got to be, at some point, there's got to be some kind of a common standard that applies to both parties. That's what we would urge. And we've had enough time, and we still have plenty of time between now and the June trial date.
Mr. Gale.
We're getting so far off track of what the motion is here. Are we arguing the whole issue as to whether Dr. McKay can testify right now, or are we waiting to do that?
Sounds like we are.
All right, well, are we going to argue all the objections in her deposition and everything about that, or just the issue of whether she was properly listed as a witness?
Well, I think I'm ready to make a ruling on that, but if you have another position or another argument you want to make regarding that, please do.
Regarding whether she was properly listed as a witness?
Yes.
I guess I would rest on what I'm saying. If the defendant is arguing that he wants to now make the same issue with Dr. Algren, if I'm raising the issue, he didn't object to it. If he wanted to, he objected to it months ago. The court adjourned the trial 5 months to allow him to conduct discovery on it. He never took a discovery deposition. He did nothing about it. If we knew, of course, my client is aware that he went to the emergency room, but there's a difference between having noticed that the defendant is going to be relying on that witness to provide testimony and him knowing that he went to the emergency room. So those are two different issues. The defendant obviously knew that he was in the wrong. That's why he amended his witness list and called it a condensed witness list and added her and other witnesses. So on that issue, that's all I'll say about that. She wasn't properly listed as a witness. I suppose we still need to resolve the issue of this order on the motion and limiting.
Well, let me address that part here first. I guess one thing that I've learned when you have trial dates, we set the final trial witness list dates to be provided because we know that the trial is coming. That's just simply that. If the trial is in June, March 1 plaintiff, March 15 defendant, I believe that's how we typically do it. And the whole idea is so that's finality, there's no surprise, there's nothing going on. Trial date was adjourned. The trial date was adjourned until January. According to defense counsel in this case, notice was provided relative to either ER physicians or treating physicians, but nothing by name. There was McLaren listed as well, but nothing by name. Plaintiff's position is, well, wait a second. How in the heck are we supposed to run a railroad that way if we don't have this information? Which clearly makes sense. And then when you put it all together, you move the trial date to January. Information is apparently discovered in December. Records were apparently not provided timely, not from plaintiff's counsel issue, but with the insurance company sending over records and finally getting to the defendant and then finding out who the ER physician is. And then the final condensed witness list, condensed, I say in quotes, was provided by the defense. It would stand to reason that discovery was still going on. And as a result, the witness cutoff date should have been changed. They really should have been. And the whole purpose of that is so that we have a final witness cutoff date. And this is what the court's going to take moving forward in these types of cases. If we have to adjourn a trial date, which the court doesn't like to do, but if we're going to adjourn trial dates in these matters, we're going to have to change the witness cutoff date if discovery continues. Now, it did for up until, I know the court ordered discovery stopped at a certain point here. I can't remember the date, and it was referenced in your pleadings as well. But how I look at it is this. I don't want to create a trial by sabotage. I don't want a situation where neither party knows what the other party is doing relative to who they may be calling in trial. It's unfair to both sides. And frankly speaking, it's a waste of the jury's time because we're sitting here arguing these issues, not now, but at trial, and it's going to be a mess. So as it pertains to Dr. Algren and Dr. McKay, from the court's position, because we have time until the trial date, which is June.
Yes.
Those witnesses are to be added to the witness list. The court's granting that. What's the date in June?
June 23rd.
So what would be the normal motion or the final witness list cutoff date that you would ask me to do if we have that June trial date? Talking May or April this month?
May 1st, May 15th.
May 1, May 15. That's it.
Not that close.
May 1 plaintiff, May 15 defendant. If you don't have your witnesses there and you come in and you say, I want to call this other witness, let it be known if the motion will be denied. Just making it clear.
Your Honor, if I may just jump in, I mean, discovery was closed before defendant filed this amended witness list, and the court ordered discovery to remain closed since the morning of the prior trial, so.
I agree with that. But here's the issue though. According to the defendant's counsel in this case, they didn't know of this witness. They listed an ER treating physician at McLaren, but they didn't have a name at the time. That's how I understand it.
I don't believe that's true, Your Honor. I believe this was even argued in like a facilitation summary, which.
Well,
I think, Your Honor, I thought that listing by category in that context would be sufficient. I didn't know there was going to be an issue. That's how we do it. And I don't believe I've ever had this before, where somebody said, you have to spell it out for me.
Well, I'm going to make a ruling on it, and I find that's proper in this case. But I prefer not to do it that way. But that is a treating ER physician at McLaren, whether he knew the name or not. But now, because it's all out there, it's fair for both sides to address whatever issues they need to address relative to those prospective rules. Relative to experts, though, defendant is not calling any expert witnesses. That's what he has stated before, and I don't believe that has changed. However, as I've ruled before, if the defendant's attorney cross-examines the treaters or the other expert witnesses who may be called by the plaintiff, if he can get an opinion that follows the rules of evidence and the rules of law, he's entitled to do that. He may not be able to, I don't know. But I think that's fair game in cross-examination. So to make that order clear, that's the court's position.
Just to be clear, the only thing the court was ordering in that is just that the defendant can cross-examine the doctors we call.
Correct.
Okay,
Correct. He can't call. Well, wait a second. If Dr. McKay is not called by the plaintiff, that's the issue.
Dr. McKay is a treater. That's what I understood from December. We were allowed to call treaters. Dr. McKay, I may call other treaters, but right now, Dr. McKay is the one who's already testified.
She's not testifying as an expert, though.
She's a doctor. I mean,
Right.
This is a great
What she
area.
did.
Different judges have different views of that. I've had judges before in the last year say, I don't consider the treater an expert. I consider the expert somebody you hire to give an opinion. You pay them and they work with you. Except the doctor has to be qualified. You can't call a podiatrist to testify about a brain tumor unless they're also board certified. So I think in terms of MRA 702, when I say expert, with a small e, I guess, I wanted to make sure it was clear I could call treaters. And we went into detail on this on the 16th, and I laid all my concerns on the table, and that was my understanding is I would be allowed. I think now Dr. McKay is specifically listed. And again, if there's any concern about her testimony, we'll just do it again, or I'll call her live. It was a deposition that can be used as trial testimony.
It was done at the last minute,
It was done on the same day as Dr. Albrecht.
right? Both sides. Go ahead.
first of all, it didn't have to be. If he felt like taking it sooner, he was more than welcome to it. He felt like, to raise after the fact that our deposition is too late, which he did on the morning of the trial, and his was after ours. It's just an unusual thing. He should have noticed it sooner if that was an actual issue he wanted to bring up to the court.
I didn't say it was too late. I was prepared to cross-examine Dr. Albrecht, and I'm satisfied with that. Subject to the objections that were made that we can't just have the jury listen to.
Okay, but just to get back to what we're
Why would I
talking
take
about.
Dr. Albrecht's deposition when I have his records? I asked for the opportunity to get his records because I didn't have them. The court granted me that. I obtained his records and I was prepared then to cross-examine him. I'm not calling Dr. Albrecht. So when he says you could have taken his deposition, I'm not gonna do the trial testimony of any of his witnesses. He's gonna have to do that. But Dr. McKay, I want to call, and I get the feeling that he doesn't like what Dr. McKay has to say. So I wasn't gonna wait for him to call her. And then I would cross-examine. That's why I brought it up on the 16th. But I think the court has resolved the problem with this deadline for disclosure. And then we can talk about individual objections separately.
Right, because one's going to be coming regarding, it's already been filed actually, relative to having Dr. McKay testify.
Yes, there was one filed and there were numerous objections to the conduct of the defendant's counsel, and I don't know if the court has seen that or got into that at the deposition of Dr. McKay. So, we keep getting off track. Just to stay focused on this, I believe you were saying the issue is whether Dr. McKay would be an expert or not. I think the issue would be what kind of opinion is she offering? Is she just offering fact testimony?
It appears it's fact testimony only. I
Right.
thought maybe called as an expert regarding a condition, but if I recall, looking at the information provided in the court file, it appears regarding an ER visit, and that was it.
But the defendant did try to ask questions. See, this is where there's an issue where we would have been entitled to know in discovery whether he's offering an opinion like this. From what I recall, on the top of my head here, I believe he asked questions like, can you say within a reasonable degree of medical certainty that Daryl Curtis did not fall? That's like an expert medical opinion. That has to be disclosed. We have to know that he's offering testimony like that. I don't even know how she could possibly say anything like that. So there's different foundational issues, but that is an expert opinion. So I think it depends. It's not necessarily the person, it's what type of testimony is given as to the order excluding expert medical opinions.
You know, that's, if I may, that's not a good example because as you can see from the transcript, her answer was, he gave no indication that he had fallen. And in fact, this is what he told me factually had happened to him. So what you were saying earlier is more accurate.
Medical opinion.
Well, she's an emergency room physician who saw him on the day that he said he fell 22 minutes earlier. That's what he said. He didn't mention a fall. He didn't mention any acute injury. He said, it's been getting worse over the last couple of days. He described the exact same scenario, including the sciatic transmission down his leg. And what did he tell you? Based on my records, this is what he told me. Okay. Is there any evidence that you felt? Not that I'm aware of. Something like that, I'm paraphrasing. I asked the question, she answered it. And that's what we have to work with at this point.
Is there any evidence that he fell for using your question? I mean, I'm assuming she can only base that upon his alleged statements and or his appearance at the time.
That's correct. Her perception.
But if we, so for example, the court ordered on the, and there's so many issues here, but the court ordered on the morning of the trial that the defendant was required to respond to a request to produce that he sent, where Joseph Nolan had testified that Mr. Curtis complained or reported the fall the day that it happened, and he recorded it.
Recall that.
And the court ordered that the defendant was required to turn this over. How the defendant didn't turn this over with his initial disclosures or at any point prior in this case, without us even asking, is ridiculous in and of itself. But the defendant did turn it over, and there's record in there showing that he did report that he fell. If I knew the defendant, this is where the notice issue is. It's not that my client didn't know he went to the ER. If I knew the defendant was going to be using this witness to offer some opinion that, within a reasonable degree of medical certainty, he didn't fall, I could cross-examine her with those documents, which were withheld and never given to me. But I have to be on notice as to what type of opinion is being offered, right? That's only fair. Otherwise, I'm left blindsided. Even the defendant today saying, we may call other doctors. How am I supposed to sit here and just completely guess as to who we may call and who we may not call? I have to be put on notice. Even if my doctor knows he treated with doctors, what opinion is the defendant offering so I can prepare to cross-examine and prepare my case? Otherwise, I'm left in the dark.
Your Honor, that's not the question I asked her. I asked her about what her records reflected properly, and I don't agree with the Merrill decision. He mentioned that 2 or 3 times. I'm not arguing about that at this point until the court asked me to. Dr. McKay saw him at the emergency room and said what she said. The notes that Mr. Nolan referenced in his deposition were not requested until they were. You said, go ahead and produce them. That's a mischaracterization of what they said. And I think that it's pretty clear that they think that he's lying from his contemporaneous notes. And if he needs those to refresh his memory at trial, that they may be appropriate to use for that limited purpose. But I said, hey, do you have a file or don't you? And he produced the file. It also shows that the lease is as we represent, and that it was given to Mr. Nolan at the time that we say it was given to him. So there's a whole bunch of things that were just conveniently left out. I don't think that's before the court today, though. And so I'm trying to restrain myself by this point.
Well, what's before the court right now is this idea of expert witnesses. And the court finds that other than what may have been reported or provided to Dr. McKay at the time, if you're asking for any degree of medical certainty relative to anything that a slip and fall occurred or whatever that may be, I find that requires expert opinion. That's my finding.
And therefore she can't offer it?
Cannot offer it.
Unless she's listed timely.
Wow.
No, the court
What's
already
the
granted our
problem?
motion.
I don't understand
They
what the
can't
problem
call
with her is. I can't ask doctors medical questions, but the plaintiff can. I don't understand what plaintiff counsel's problem is with Dr. McKay.
I'm presuming that he's not calling Dr. McKay in his case in chief, that you would be calling Dr. McKay in your case in chief.
I'm calling Dr. McKay a treater, yes, in my case in chief, and I may call I had planned to call other treaters potentially.
Well, I think he needs to get notice of that.
Then we have to take Dr. McKay's testimony again. If that's true, I mean, I say that's a mischaracterization. I'm looking for the actual question and answer.
It's cited in one of the
It's one of the last things in the transcript. We should go off the actual transcript and not either of our
going on
recollections.
5 months of memory, so I could be wrong. Yeah, so here on page 32, by Mr. Friedel, within a reasonable degree of medical or scientific certainty, is it your opinion, doctor, that Mr. Curtis did not present with a direct injury on 2/27/2023?
The answer is, I have no documentation within my history or physical examination of the patient about having a fall or the direct injury. So she doesn't offer an opinion. She states what her file contains and does not contain.
I will note I properly object to the foundation there,
You did.
which is highlighted by defendant's counsel.
And then she gives the answer that she gives, which doesn't involve an opinion.
Again, it gives the impression to the jury that it's being a medical or scientific opinion.
She is a physician
Okay, and then therefore,
He
I
knows
would
that.
know that opinion would be altered.
and he knows who she is.
And
And
then, as far as the court's concerned, then relative to that, then you may need to set up another deposition.
we'll do whatever we have to do.
Because to me, that's leaning toward, not leaning, it's clearly showing, it's expressing a medical opinion, a professional medical opinion. So proper notice needs to be provided.
Well, if we have listed her now for several months.
You have. But go ahead.
I don't believe we were ever asked what opinions we were going to offer. He says expert witnesses. And again, when it suits them, when it suits plaintiff, they say, well, everyone's an expert. But when it doesn't, then a treater is different.
Well, I'm gonna run it through the tape on this one.
All they have is the records to go by. That's
Right.
all we know. And they have those records.
I'm up here standing at the podium talking about my motion to exclude the defendant from offering expert medical testimony. That's how it's all weaved around back to this. The question is whether the court granted that motion. We've gone through that.
Right, at the time. And the court's going to reverse itself and require, if there is expert opinion, it must be provided the notice by the date that was cited by Ms. Hatch, May 15. And proper notice, all the requirements, we're gonna run it through the tape as if this is our first trial day. No surprises for anyone. Applies to both counsel. And frankly speaking, the court has had the benefit of time to see how this case is developed relative to how these witnesses have been discovered and or brought to the attention of opposing counsel. Frankly speaking, I just want completeness here. That's all I want. I don't want any guessing games when 6 people are seated over there.
Fair enough.
Next issue.
All right, I guess I'm not clear how so is the order, is now the order granting my motion now denied?
Yes, I reversed myself. The court reversed itself. Well, counsel, please don't chuckle. I'm trying to be fair, but understand how this case has developed over time. And when I read that with a degree of medical certainty, well, that's an expert opinion. He never intended on calling anyone as an expert. That was clear at the previous hearing that we had. Now, when I look at the deposition testimony, it appears to the court that it is an expert opinion. And as a result, he has to follow the rules just like anyone else would. So that's why I'm making my decision as it is.
Understood.
What other issues should we address, counsel?
We have jury instructions, which is up to the court.
We're going to hold off on that.
Yeah,
We're going to have a final pretrial date on this as
I
well.
think probably in view of what we've just discussed, that the trial testimony proposed redactions, which again is that's not a motion per se, it's submitting to this is what we've done in many other circuit courts. We submit to the court what we respectfully believe the court should do with objections, and then the court tells us what it's going to do. That's what we intended there. It wasn't necessarily, I noticed it up for today just to make sure the court was aware. We have a motion about Dr. Algren in limine that I have not received a response to, and also a motion to allow it because it was technically 7 days late. Dr. Algren didn't give the testimony that gives rise to the motion until after the deadline. And so that's 2 motions in a nutshell. Willing to wait on that too in view of what we just discussed.
I think that would be wise.
I don't know that there's anything else Mr. Gale can correct me if I'm wrong, I'm looking at the list of, we had a gigantic list today and it just kind of got cut down by two
Motion
thirds.
for reconsideration. Defendant's objection to court orders. Plaintiff's notice of objection to defendant's extremely untimely trial witness list. Plaintiff's notice of objection to defendant notice of defendant essay. Dr. K. Defendant's motion limited regarding Dr. Algren that was filed January 2nd. That's what we're going to hold off on. And then the proposed trial testimony redactions that was filed December 31. Anything else we're missing?
No, Your Honor, and just so that you're aware, we were able to get in to see Dan McCarskey to remediate. That's coming up. I don't have the exact date in my head, but it's in the next month or so. So we're still on track to see if we can resolve this. We're going back to mediation.
Mr. Gale, do you have anything else other than the other motions that we're holding off?
I guess the only thing I'm concerned about here, and I don't mean to keep, the defendant has raised so many issues and we've gone through all of this, but the requested jury instructions, I guess I don't know what defendant is wanting to argue in front of the court, but the court has now dismissed this common law claim. The defendant has never filed an express motion on this issue, but he keeps alluding to it and has included it in his jury instructions that if it's only a statutory claim, that only contract-based damages can be awarded, and he included all of these jury instructions. So I think that was his hope in getting the common law case dismissed, or the claim dismissed. I've cited that Oakland County Circuit Court case that defendant touched on earlier, even though it wasn't an issue yet. Does the court want to address that now, or should we hold off on addressing that?
I can clarify that mischaracterization of our position. We do not assert that they're, at this point in time, that they're confined to contract damages, in other words, foreseeably, I can't remember the word.
Let's make it simple. Let's resubmit the instructions.
Exactly. That's what
Just
we do.
resubmit them. We have time. Resubmit them, their objections, we'll handle it at the final trial date,
All right.
which Ms. Hatch will schedule.
Let's do that.
3 weeks before trial, would that be satisfactory to both counsel?
Sure, Your Honor.
May 29th, it's a Friday at 1:30.
Give me some time for my glasses.
Okay.
I thought older people were making this kind of stuff up when I was younger. You said May 29th.
Yeah, I'm attending a seminar that day. I can't.
I have 2 depositions on that day that I could move if necessary.
Okay. Let's go off the record.
Sure.